Good evening to all of you. Wish you happy Dasara. Wish you happy Vijayadashami, Durgashtami, and so on and Mahanavami, so on and so forth. We are assembling on a very auspicious day, that is on the day of Vijayadashami. The leftover sections of the Guardian and Wards Act, we'll discuss it today. We have completed up to section 38, right of survivorship among joint guardians. Suppose, let us say, more than one guardian is appointed and the one guardian one of the guardians expires. Then in that case, till the vacancy is filled, the surviving guardian can act as the guardian on behalf of the deceased guardian also. That's what section 38 deals with. Then section 39 is the section 39 gives the power to the court to remove a person who is appointed and declared as a guardian on certain grounds. Suppose the guardian is guilty of acts of negligence, want of diligence, or carelessness, or he acts for the benefit of himself and not for the welfare of the ward who is under his custody. Then in that case, or let us say acts in a manner which is detrimental to the interests of the minor, then the court, on sufficient grounds being shown, can remove a person who has been declared as a guardian of the minor ward. That's what section 39 deals with. Today we go into section 40. The guardian can apply to the court in case he wants to resign. I told you also sometimes what happens is all of us have some preoccupations or other. We may not be able to devote our full time and energy. We may not be able to take care of the minor, or we may not be able to devote as much time as is required to take care of a minor ward. So in that case, suppose let us say, or my health is not good, I don't want to continue physically and mentally, I am completely drained. In that case, I can ask the court to permit me to resign from the guardianship, and the court, for reasons shown, accepts the resignation and appoints some other person as the guardian of the ward. That is what section 40 deals with. Then section 41 is cessation of authority of guardian. When the cessation means, when does the authority of the guardian ceases? One, the death, physical death of the guardian automatically puts an end to the guardianship. Then the second one is court of wards assumes superintendence of the property. So as far as the Sarfakas Mubarak or the court of wards is concerned, it assumes or takes control of the custody of the minor and also his welfare and also his property. And the third one is the female, that is as far as the third consideration is that the ward ceasing to be a minor. Please remember, in the suppose the ward attains the age of majority, completes the age of 18 years, he can no longer be called as a minor, and the guardian who is appointed as far as the minor is concerned is discharged from his duties, and the person concerned who is a minor will be declared as a major. And there is a proceeding also provided in the Civil Procedure Code. If I am correct, the correct procedure is Order 32, which says whenever a person attains the age of majority, you can file an application to discharge the guardian and to declare the minor as a major who has completed the age. So what is the advantage of that, sir? The minor gets all rights. He can initiate independent action. He doesn't require the services of the guardian, and he can take all steps which are necessary for his upkeeping, so on and so forth. So once the minor attains the age of majority, the guardianship automatically ceases. And last one is female by marriage. Please remember, perhaps because of the restriction imposed by the government now, a female child cannot marry before she attains the age of 18 years. And as far as a male is concerned, he cannot marry unless he attains the age of 21 years. But please remember, in villages and in places where the literacy is not to that extent, mostly once a female child attains the age of puberty, the child is married to a person concerned. Then once the marriage takes place, as far as the female child is concerned, then in that case the guardian loses his guardianship and the husband becomes the guardian as far as the minor female is concerned for all practical purposes. That's what section 41 deals with. Then 42, that is 41, deals with cessation of authority of guardian. There are four instances. One is once the minor attains the age of majority. Second one is when the guardian expires or dies, or when the court of wards assumes superintendence over the person and the property of the minor. And then fourth one is when the female gets married, her husband becomes a natural guardian and the guardian appointed the court, his authority terminates. Then we go to section 42. Appointment of alternate guardian on discharge of previous guardian. That is, suppose let us say previous guardian is discharged for any reason, either by his death or by the court of wards taking custody, so on and so forth. Then in that case, an alternate guardian, a substituted guardian, is appointed by the court as far as section 42 is concerned. Then 43 is, please remember, that the guardian should not be given a free hand. There should be checks and balances. There should be control. There should be supervision, or there should be someone to guard their to watch their actions. And that is the reason the actions of the guardian from time to time will be watched and supervised by the court, and then they are also answerable to the court, and the conduct of the guardians will be watched very, very carefully by the courts from time to time. Then 44 is penalty for removing a ward from the jurisdiction of the court, punished for 6 months or fine of 1,000. Suppose, let us say, deliberately you remove the ward from the jurisdiction of the court where you are appointed as a guardian, and the ward is removed from the jurisdiction and taken to some distant place, and in that case you will be brought to the court, and then you will be penalized to the extent of 6 months imprisonment and 1,000 rupees fine is imposed. When it is imposed, sir? When you remove the guardian, when you remove the ward from the jurisdiction of the court without the permission of the court, then in that case, penalty is imposed in the form of imprisonment up to 6 months and fine of 1,000 rupees is imposed. Then 45 is penalty for contumacy. A person who has been released from detention as giving an undertaking fails to carry out the undertaking, he can be committed to civil jail. That is, a person who has released from detention is giving an undertaking, fails to carry out the undertaking, he can be committed to civil jail. That penalty for contumacy is a person who has been released from detention in a court, and then he comes out, and then what he does is he gives undertaking of good behavior. Then the question is, if he fails to carry out the undertaking, he can be committed to civil jail. So a person who comes out of detention and then he gives an undertaking of good behavior, or he gives an undertaking that he'll take care of the child, or he is the guardian of the child and still flouts that undertaking, then he is committed to civil jail. That is, he can be punished by imprisonment being imposed. And this violation of the undertaking is called contumacy. That is a bond which you give to the court, that you will take care of the child, you will look after the child in all ways, though you have come out of detention. But once you violate that undertaking, you can be punished and you can be sent to civil jail. Then 46, court can call the collector or any court subordinate for a report in any matter, and report can be treated as evidence. So the collector, sometimes the court can always, because the collector is supposed to be the head of the district as far as revenue matters are concerned, court can call for a report from the collector as far as the welfare of the minor is concerned, how he is being looked after, whether the guardian is carrying out his duties properly or not, whether the property of the minor is looked after properly or not, or whether the guardian is acting with due diligence without any negligence, or there is no dereliction of duty on the part of the guardian, and the primary welfare of the minor is taken care of, and the directions given by the court are observed in the letter as well as in the spirit. then the court can call a report from the collector, and the report given by the collector can be treated as evidence as far as the guardianship cases are concerned. Then, sir, section 47 says, since the all proceedings under the Guardianship Act, Guardian and Wards Act are filed before the district court or the family court as a GWOP, there is a right of appeal also that is provided under section 47 of the GNW Act. Sir, you can ask me, sir, which is the court to which an appeal lies? As far as the GNW Act section 47 is concerned, since the order is passed by a district court against which you want to file an appeal, the appeal lies to the High Court within 90 days. Within 90 days from the date of the order. Then, sir, what you are supposed to file in the appeal? In the appeal, you will have to allege and contend that the orders of the lower court or the orders passed by the district court is fallacious, erroneous, against the law, materials, evidence, and preponderance of all the exhibits that have been filed into the court, and you will have to allege and contend that the lower court has not considered the welfare of the minor, and it has passed an order on surmises and conjectures without proper reasoning, or you point out the evidence, the inconsistencies, the contradictions. As far as the evidence is concerned, you point out the consistencies and then file an appeal. An appeal lies to the High Court under the appellate jurisdiction, and normally all GWOPs are numbered as CMAs. Or if it arises from the family court, it is numbered as FCMA. And if it arises out of the civil court, district court, it is numbered as CMA before the High Court. And please remember, the limitation is 390 days from the date of order, and the time for taking copies will be excluded for the purpose of limitation, and the appeal has to be filed within a period of 90 days before the High Court. And suppose you lose in the High Court, then you can go by a special leave as far as the Supreme Court is concerned. Then we go to, sir, section 48. It says finality of other orders. Suppose miscellaneous petitions are filed, orders are passed, interim custody has been granted, temporary custody has been granted. As far as those orders are concerned, they are final unless it is challenged in the superior court. That's what section 48 says. Then 49 speaks about costs of maintaining the guardian in jail is subject to the discretion of the court. Please remember, it is easier said than done. Suppose the guardian commits any violation of the terms of appointment, or he usurps the property of the minor, or uses it in a manner beneficial to him and to the detriment of the minor, does not act as per the directions of the court, or violates the directions of the court, then in that case, I told you, he is arrested and kept in civil prison. But as far as the cost of keeping him in civil prison is, that is the person who sends him to jail. The person who complains against the violation, he will have to, according to the discretion of the court, the cost of maintenance of the person concerned has to be met by the concerned person. That is, diet charges has to be deposited. Please remember, suppose a person is acclimatized to take meals 5 times, you will have to pay the charges for that meals. Sometimes it is something like maintaining an Airavat, that is a white elephant, and sometimes you regret why you should send that person to a civil prison, and he can be arrested only for 3 months, not more than 3 months. And once you arrest him in 1 year, the same year you cannot re-arrest him again. Then, sir, as far as section 50 is concerned, the rule-making power is given to the High Court. As far as the High Court is concerned, of the respective states, they have got the power to frame the rules, regulations, and the conditions which apply to the Guardian and Wards Act. Then, as far as the costs are concerned, it is the discretion of the court. Please remember, in a guardianship OP, no costs are awarded. But it is a discretion. Suppose the court wants to grant cost, it can grant cost at all cause at all levels. So this is as far as the GNW Act is concerned. And in the next class, we will just deal with some of the judgments as far as GNW Act is concerned. But before that, we will have an introduction to another enactment called the Hindu Law of Adoption and Maintenance Act. Hindu Law of Adoption and Maintenance Act. Here, this is a special law which governs adoptions and maintenance. First and foremost is what you mean by adoption. Adoption means where the childless couple who do not have children, there are no chances of their getting children, then in that case they can apply, they can adopt any child and take that child into their custody. Please remember, please remember this law of Hindu law of adoption and maintenance applies only to Hindus. It does not apply to Christians. It does not apply to Muslims. Why? Because in Muslims there is no system of adoption. What is followed in Muslims is only fosterage, and in Urdu they call it as palakada. Palakada means where a male child from another family is brought into the family, looked after and managed as if he is a son, as if he is a son, and then he gets all the rights. But as far as inheritance is concerned, an adopted son or a foster son, in Muslim law has no right of inheritance. Even in Christians there is no system of adoption, but only in Hindus, and this enactment is specifically named as Hindu Law of Adoption and Maintenance Act. That means it applies only to Hindus and not to the other communities. Please remember, if you see Article 25 of the Constitution, the word Hindu has got a wide connotation. Hindu means and includes Hindus, Brahmins, then you got what is called the Vaishyas, then the Kshatriyas, then you got the Sudras, then you got the Sikhs, Parsis, and Parsis, and so on and so forth. So the term Hindu has got a wide connotation. And please remember, if you know the genesis of the Khalistan movement in Punjab, the Sikhs were agitating. They wanted to get the word Hindu removed from their caste. They wanted to be recognized as a separate community by itself. But the government resisted it, and that is the reason why the Khalistan movement took place in Punjab. Of course, the genesis of that is not that. The reason is narcotics was being smuggled from the borders of Pakistan to reach Punjab. In return of what is called arms were being sent from Punjab to Pakistan. That was a regular trade going on. Even today they say there's a regular tunnel from Punjab to Pakistan. And that is that if you go to the airport in Punjab, in Chandigarh especially, or Mohali, it's heavily secured because it's almost a border, touch and go. You have to be very, very careful, and there's a lot of checks and balances there. And that's a part. Then we go to Hindus. As far as Hindus are concerned, if you go into the sources of Hindu law, and the first Smriti, or the saying of sages, was Manusmriti. Manusmriti says the idea of marriage is bringing the male and a female together in a wedlock to procreate children and to perpetuate one's own descendants, and also to provide a male issue for the purpose of offering pinda to the deceased. And that is the reason it is Manusmriti is followed everywhere, and it's a source and inspiration for the entire Hindu law. So in Hindus, we have got three types of children. One is called Aurasaputra, another is called Dattaputra, and another is called the Dasiputra. As far as Aurasaputra is concerned, where the female, that is the wife, undergoes a regular pregnancy and delivers a child after 270 days or 280 days, then it is an Aurasaputra. Dattaputra means a child which is taken into adoption in the family. It's called the Dattaputra. And Dattaputra is almost equal to Aurasaputra for all practical purposes. He gets all the rights of inheritance, all the rights of succession in respect of adoptive parents as well as the natural parents also. He is the darling of the family. Then you got the Dasiputra. Dasiputra means a child that is born to a Dasi or to a concubine. The Supreme Court was asked to interpret whether the Dasiputra is entitled for all rights or succession. The Supreme Court said, as far as a Dasiputra is concerned, a Dasiputra is also entitled to succession rights provided the child is born to an exclusively kept concubine or mistress of the person concerned. If you see the mythology, in mythology if you see, Vidura was supposed to be a Dasiputra. Vidura was born to a Aya of that particular kingdom, and Pandu as well as Dhritarashtra were also born through other means. That is by consuming the payasam, and they conceived. So the question is, for all practical purposes, the scheme of Hindu law is that the Hindu law of adoptions applies only to Hindus, not to non-Hindus. That is, it does not apply to Christians. It does not apply to Muslims also, because there is no scheme of what is called adoption as far as Christians and Muslims are concerned. In Muslims, you can bring a male boy from another family and bring up that boy as if he is your child, but still the child will not get any rights over inheritance as far as the father's property is concerned. The same way Christians also cannot take adoption. Adoption is not permitted among Christians. The only community which permits adoption is Hindus. The first definition that is given in the section 3 is custom and usage having been continuously and uniformly observed for a long time obtains the force of law among Hindus in any local area, tribe, community, family or group. That is, having been continuously and uniformly observed for a long time. See, there is a community called Lambadas, who are STs. STs also come within the definition of the word Hindu. Among the Lambadas, suppose the husband dies, the husband's brother, who is our brother-in-law, gets a preemptive right to marry his sister-in-law. And this is a custom being followed in from times immemorial, continuously without any interruption among the Lambada community, that is the ST community. So the custom sometimes overrides the law. So the question is, the brother-in-law gets the preemptive right of marrying his sister-in-law provided she is of a lesser age than the person, the brother-in-law concerned. Then you find what is called in different kinds of marriages are there. So I think perhaps you know it. The kinds of marriages, the Gandharva marriage, then you've got the Rakshasa marriage, then you've got the elopement, then you've got what is called the natural marriage, then you've got what is called exchange of rings and exchange of garlands, and then you've got the Chira Ravika marriage, so on and so forth. There's a custom. This is being observed from times immemorial, continuously by a particular community, within the particular group, or within a particular tribe. Then it gets the sanction as far as usage is concerned, and it's a custom which has to be respected, which has to be followed, and which has to be implemented. So the question is, sometimes what happens is custom overrides the law, provided it is followed from a times immemorial among a community, among a class, among a tribe, among a group of persons, openly, notoriously, continuously, without any interruption, and which has been observed, and it has assumed a legal sanction, and it's implemented. It is called custom or usage, and it is normally implementable. So the question is, sometimes custom plays a very important part. So the question is, how it is being followed, how they are in a particular tribe, how it is followed in a particular community, how it is followed in a particular group of persons, how it is followed by a certain group or so, a certain family or so on and so forth. But the question is, suppose this custom has been given up, it is not being followed, or it has been discontinued, then from the date of discontinuance, custom will not have any effect. Then second one is, second definition that is given is maintenance. See, after all, everyone to keep himself or herself alive, or to keep the flesh and blood together, we require food. Then there's a joke also about that, whether you eat to live or live to eat. The question is, in Russia they say, one who does not work shall not eat. So the question is, you have to work, you have to spend your sweat and toil, and then earn money and then eat. But you shall not always be eating throughout your life. The question is, eat to live or live to eat. That's an important thing. The definition finishes. Then the question is, as far as maintenance is concerned, a person requires the basic necessities, that is what is called roti, kapara or makan. So for that particular purpose, they may not have sufficient means, but those means, that is the reason why the law of maintenance has been provided, to see that no one goes as with hunger. The last definition is minors. That is, a minor, everyone knows, who has not completed the age of 18 years, such a person is called a minor. So with this introduction to the Hindu Law of Adoption and Maintenance Act, we shall, because I don't want to trouble you on this festival day, again wishing you all a happy and prosperous Dashera, and also let Dashera give you the light and also the vision and also the guidance in your future endeavors. Thank you very much.